Yes, Mr. Harrison.
Thank you. Just before I continue, I've emailed soft copies and also have handed out hard copies of an indented copy of the rules.
That's very helpful. So that's the first stage in our inquiry, and that's useful to have. It doesn't answer the question, which only came up because one of you said it, that this version is only available for archived rules, and if you want to find the current rules, they're not available in this format. That strikes me as slightly surprising, but that is what I understood one or both of you to say. So we'll come back to that at the end of the hearing, unless you can tell me that's definitely not the case.
No, I can't tell you that's definitely not the case.
We'll come back to that at the end of the hearing. Now, yes.
So, is this the currently enforced version?
No, this is the version that was laid down with the statement of changes.
In 2020,
So
whatever.
Yes,
because there are literally, I imagine, well, for most of the immigration rules, I'm sure for Appendix EU as well, there's likely to be 2 or 3 changes a year.
Exactly. So this is specifically the ones that came to introduce the change that we're looking
This
at.
is April 2023, I think.
And so there are certainly several versions since then, or more than one.
I understand there are, yes. And as I said, I'll
okay. Well, we will ask for a note at the end, unless you can assure us on that. But we won't go and say any more about it for the moment.
Just while we're on the sort of nerdy format points, in this as we have it, there are some use of bold type, which I think is some cross-referencing, but it's if that's what it is, it's almost random. That some phrases are in bold type, and some phrases which are definitions are not in bold type. Can you say what the significance of bold type is?
Would you mind if I just see if someone has the answer to that? I'm told that a bold type is used for the first time that a definition appears in Annex 1. If we look at then durable partner, I'm sure I'll be corrected if I'm wrong, when we turn to page 441 of the new version, which is the one I'm looking at, durable partnership of convenience is bold. So I expect that means that this is the first time in Annex 1 durable partnership of convenience appears.
Sorry, where can you speak up?
So I'm in the copy I just handed up. I think probably the same must be true for the earlier.
Give us a page number.
Page 441. At C, you've got, in the definition of durable partner, you've got durable partnership of convenience.
So that's bold type. That means this is a defined term, but
it isn't a defined term.
But it's not. It's not a defined term.
It is actually, but it appears in the wrong place, I think.
There was a time when these definitions weren't in alphabetical order for some of the annexes, but these ones are, aren't they?
This one isn't.
Of course, durable partnership of convenience is under C, following civil partnership of any convenience, as any fool would know. Well, really, that's hopeless.
How is anyone supposed to find it?
By reading the entirety of Annex 1.
You'd have to read the whole thing to find.
I'm afraid there's a limit to how
Can
much
I
time
make
can take
one
on this.
comment, which is in modern approach, which is not too much to ask, particularly when things are on the internet, is that use of definitions should be hyperlinked. And that's particularly so when you've got however many pages of definitions here. That would deal with this problem at a stroke.
And whether it's hyperlinked or simply indicated in bold, it should be every time it appears. It may make it rather messy, but how are you to know something, if you were reading a definition rather late on in the annex, and it uses a defined term, and it's not in bold because it's been bold the first time it was used, you're never going to know it was a defined term unless your instinct tells you it must be, and you look for it. And even then you may not find it because it's not in alphabetical order.
All comments I have no response to. But
no, I know. It's to some extent us letting off steam, but it's not. Well, there are representatives of the department in court, and they will see the point. There's also a rather odd one here, just while we're about it, but I suspect has no significance. There's some passages where instead of a purple background, the purple background is whited out. Page 447 and 448.
I also noticed that. I don't think I'm likely to be able to provide an explanation, but I suppose this actually...
It probably has got an explanation, but since nobody's told the code, they can't make use of it. Well, okay, we'll stop kicking you around, but it's not you who deserves to be kicked. But thank you for this, and we'll be asking for more at the end. But where we were following up something which, perhaps for understandable reasons, was not really covered in the skeleton argument and didn't feature very much in the UT's decision, namely the difference between vanilla family members and joining family members, and whether AAA applies only to joining family members. For the reasons already given, we do want to understand that, but we also appreciate that that's not ultimately, on the way the case has been presented or argued below, the decisive question in the case. If there's more you can say to follow up what you said before, maybe you've had the benefit of some discussions over lunch, we'd be very grateful for it. But there may be a limit as to how far we can take this.
I'm grateful for that. And there are a couple of more observations that I'd like to make.
Yes,
if that's
thank
okay. All I would say is that obviously prior to lunch, the Secretary of State was aiming to set out how the Annex 1 operates and how the terms fit together. And I think where we left things was we'd kind of got to the conclusion, which is where the Secretary of State started in presenting this case, that really what we're looking at is how AAA operates, and if we achieve one outcome, which is the appellant's preferred construction, then we follow up through the joining family member route. If we agree with the Secretary of State's construction, which I'm going to come on to, we don't get into that at all. So all I would say is that the way in which we did present this case is still focused on what is still the Secretary of State's case today. I just hope that going through how...
So what is still the Secretary of State's case today?
The construction of AAA is that was set out by the Upper Tribunal in Hanny.
Yes, I've got that, but we're on the prior question whether we get to AAA in the first place.
Well, we would get to AAA if the applicant, if the appellant had a lawful basis. We'd satisfy AAA if the appellant had a lawful basis for being in the UK prior to the end of the specified
Well, that's
period.
the answer to the case, whereas
Exactly,
the answer to the case.
But it's circular because in the event that he presented material that supported that in his application, then the Secretary of State would have applied AAA. And the fact that he didn't means that we didn't apply AA. And perhaps I'm not taking matters further at the moment, and it would be more helpful to go to AAA.
But you said you wanted to make some extra observations.
Yeah, so they were short observations, and the first is really why I've drawn out the distinction between joining family member and EEA family member or vanilla family member to begin with. And that's just because if we then go to B2 in the definition of the durable partner, and we're in BB.
Sorry, page number?
Sorry, 176 of the authorities bundle.
Sorry,
176.
Yeah.
So the structure that we're looking at here is, so we're in BB, so we've already decided that this person does not have the relevant document. The application was after the specified date, and we're now seeing if either AAA, BBB or CCC can apply. And obviously AAA is what we're concerned with. But if we look at BBB and CCC just before going into AAA, we can see how they operate to allow those who are living within the UK in a durable relationship but do not have the relevant document to break the continuity of residence after the end of the transition period. So, for example, BBB allows a person to leave, and there are various more defined terms, but I'll tell you where we end up, and then we can look at the defined terms if we need to. If they break their continuity of residence by leaving the UK for 6 months, so someone who had been in a durable relationship, didn't have the residence document, can then leave the UK, break the continuous qualifying period, which is defined within Annex 1, and then after 6 months can apply to come back to the UK as a joining family member. And that's one of the main ways in which this section, B2, operates. So someone can bring themselves into the definition of a joining family member.
Why does that help them to do that?
Why does it operate to do that?
No, why does it help? Why is it a good thing for them to do?
So what it would do, as in principle, why would it be a good idea? I think the idea is that, and again, I'll be corrected if I'm wrong, but I think that the basis of this is that if one is residing under EU law within the definition of a durable partner within the definition of durable partner and have the required documents under the 2016 regulations, so they're residing properly in accordance with EU law by the end of the specified date, then under the withdrawal agreement they are entitled to have their residence in the UK recognised.
But if they're resident in the UK, why aren't they just family members?
But this is someone who, yes, they would be family members.
But you were saying that this was enabling them to become joining family members.
Exactly. So someone who wasn't residing in the UK as a family member, it's not the end of the road there. They're able to leave the country and then come back as a joining family member and bring themselves within different provisions of the withdrawal agreement.
suppose this may be a really naive question. Can you try and explain the logic of why leaving for 6 months? Why do the rules encourage you, as it were, if you're right, to leave for 6 months?
I think we might have to go to the withdrawal agreement for that. Yes? Apologies.
If you don't have the residence card, you're here unlawfully.
Yeah.
What these provisions do is allow you still to come into the joining family member route as though you'd always been overseas, which is a more generous provision than the withdrawal agreement requires.
If I go to the withdrawal agreement, just because I think it
well, look, can we just, before, I don't mind doing this, but
as in
if it's important to your submissions, but I'm really worried about this. We thought this was about a small case, about what AAA meant. And I think that is still ultimately what the parties are asking us to decide.
Indeed.
We, for reasons which I've tried to explain, nevertheless wanted to understand how the rule worked. So we needed to understand about joining family members. We started asking questions about that, and we soon got into a complete bog, and I'm not sure we're totally out of it, I'm afraid. Now, it may not matter, because we may just have to duck those sorts of explanations. But I'm afraid we're about to get into a whole new bog, based on your trying to make points about BBB and CCC. If we are going to make points and they're important to you about BBB and CCC, we've got to understand them properly. But it sounds like we'll be here all afternoon going to the withdrawal agreement. And can you just give us a headline of why it is important to you that we understand BBB and CCC?
Well, the headline, which is the only point I wanted to make about it, is the point that is made in the skeleton at paragraph 29.
Paragraph which?
29.
29.
So what we say at paragraph 28 and 29 is that the exception at AAA applies where you're looking at a joining family member, which is the ground that we've just covered, and not as a family member of a resident citizen, as we've already covered as well. And then what we say at 29 is otherwise to come within the scope of the Appendix EU definition of durable partner, it would, and therefore not require a relevant document, they would need, as it was open to the appellant to have done, to break the continuity of their residence in the UK after the end of the transition period by being absent from the UK, as per the exceptions at BBB and CCC. So all I'm trying to do is set out that the structure of B2 generally is is to address circumstances where someone wants to apply as a joining family member, don't have been resident in the UK but not as a durable partner, don't have the residence document, but have taken a step, or their circumstances are such that they can nevertheless come within the definition of joining family member. And AAA is one of those, because their circumstances would be that they actually had a different lawful basis to be in the UK. As a result, they never had the residence card. As a result, they can still come within.
Okay, so you're saying for someone who's here unlawfully, there might be a route in if they go away for 6 months.
Exactly.
But then they'd have to apply in the proper way.
Exactly.
Rather than arrive and stay illegally.
Exactly. So I'm not trying to make a wider point about what BBB and CCC mean. I'm just trying to illustrate the structure of how these provisions work.
Well, this is what I've understood you to say, and tell me if I've got it wrong. Why BBB and CCC are relevant is they simply reinforce the point that all three alternatives under BB are concerned with the joining family member route, not the vanilla family member route.
Yes, exactly. They're all three concerned with the joining.
But is that the point that you're trying to make?
That's the only point, and the reason I'm explaining how BBB and CCC work is that.
No. Well, I think, but you need to add to what I've just put to you.
No, only just to say that AAA is to be construed in relation to the provisions as a whole.
And that's the absolutely critical word, if I've got this right, and I'd missed it first time, blink and you miss it, is in subparagraph 2 of just below the first hole punch, the word joining. That makes all the difference.
It makes all the difference to how the section that follows operates, yes. But still the key question is what AAA means, and the question of whether it's lawful status or a lack of lawful status that brings you within these provisions.
Indeed it does, but there's no reference in AAA to joining family member. On the contrary, there's reference to family member, and the only reference to joining family member is further up the page in main subparagraph 2.
Yes, but we are within subparagraph 2, so again, that is how the Secretary of State understands this provision to work.
But coming back to the critical distinction being drawn between someone with, say, a student visa and here illegally,
yes,
you're not, as I understand it, relying on the concept of joining family member to say that that sort of person with a student visa could not benefit from AAA.
No.
In other words, even though they've been here all the time and are not actually joining, for these purposes at least, they could get the benefit of AAA.
Exactly. I'm not trying to defend the simplicity of the rules. All I'm trying to say is that is how AAA operates. And exactly, as my lady puts it, if a person who is resident in the UK but did have another lawful basis for being here and is able to demonstrate that, but did not have a residence card, then they conceptually will be considered a joining family member. Now, I've asked some questions as to why they were considered joining rather than a family member. No, it's a choice of drafting. There's some simplicity in the drafting choice. Simplicity being a difficult word here, I appreciate. So that is how it operates.
So is the shorthand, really, for present purposes, the whole debate about joining family member is not is not critical.
No, and it never has been to the Secretary of State. But
It's
hard
not
to get
critical to the
understanding.
dispute between the parties, as I understand it.
I'm so sorry. I think
Not critical to the actual dispute that's being argued
exactly,
about.
and that's why we set it out now so that the provision can be understood in context, but it isn't. It isn't. The meaning of AAA it turns in on that insofar as it turns on the context of the provisions as a whole, but it's not critical. If AAA is met, then we end up on that route.
And can you just help me by taking me through this? Change the facts so that Mr. Wilding's client was here as a student, but all the rest is the same. Didn't have a residence card.
Yes.
Formed a relationship, got married in April 2021, and so on.
Exactly.
How would he have qualified, if at all, under this appendix?
Exactly. So, in those facts, and there may be nuances to how all of the decision making would work that I can't pretend to be able to answer in the specific hypothetical facts. But in that situation, the person would not be able to be an EEA family member because they do not have a residence card and they cannot come within B1. We'll assume for present purposes that they satisfy A. They cannot come within B1 because they don't have a residence card. So then we get to B2 and we're considering whether any of these exceptions apply. And A would operate on the Secretary of State's reading of the provision to mean that...
Sorry, where's
sorry,
that?
AAA. Sorry, AAA. I've jumped across AA. So say the application is made after the specified date.
So he's the durable partner of...
A relevant EEA citizen, who would now be his spouse.
Yes.
He wasn't resident in the UK on the basis that met the definition of a family member of an EEA citizen, which we know because he didn't have a residence card. And then, and then we get to the unless, and then the reason why is he did not hold a relevant document, which he did not do, and he did not otherwise have a lawful basis to stay. Now, in your scenario, he would have a lawful basis to stay, which means that he would come within AAA. That would mean that he can then meet the definition of a durable partner. It would mean that we go into the joining family member criteria and we look at 14A, and assuming all of those boxes are ticked, our student visa person, our student visa applicant, would be able to come into the joining family member route under 14A, even though he's still resident in this country.
But sorry, why is the student someone who did not otherwise have a lawful basis of stay in the UK?
The student would be someone who has a lawful basis of stay. So this is where we get into the question of construction and the grammar of the provision.
Yes, that's right, because it's unless. So the unless bit doesn't apply to him because he did have a lawful basis of stay. Therefore, the first half of AA applies to him.
Exactly.
And therefore, he is a joining family member, even though it's a very odd use of joining, because joining suggests that he's coming from somewhere else.
Sorry, I'm now being slow. You accept that the person with the student visa does not fall within the first part of AAA? Because he's not resident on that basis.
On that basis, exactly. Yeah. So the basis of the residence is the core part.
But we want him, he needs to, on your construction, he therefore is relying on the unless.
Yes.
No. Is that right?
Yeah, I think so, exactly.
Sure, no. He qualifies because he qualifies under B2, BB, AAA, first half, because it covers almost everybody, as the UT says. He wasn't here as someone with a residence card.
Yes, sorry.
That's all that means.
The right way around, but
so it's a huge class of person. It covers almost everybody. So the question is then, is it restricted by the unlesses? And it's not restricted. It is restricted because the reason is that he didn't hold a residence card, but it's not restricted because he did otherwise have a lawful basis of stay.
Exactly.
And this is the exercise that the Upper Tribunal did in Harney.
Yeah, exactly. And I can take the court through the decision in Harney, but in short, that is the basis.
Well, I think we've all pored over Harney, and we weren't taken to it by Mr. Wilding. Please do if you want, but I think it's a jolly good, jolly clear,
exactly.
maybe wrong, but a jolly clear piece of reasoning.
In that case,
which you adopt.
We adopt that reasoning and acknowledge that there is complexity to the drafting and that the Upper Tribunal in various cases, and in particular in Harney, has had to unpick that, but the way in which the Upper Tribunal in Harney unpicks it is the Secretary of State's position. And what I would also say is that on Mr. Wilding's case, and if you were with me, that it would be an absurd situation if the scenario my Lord put to my learned friend earlier were to lead to an applicant who had no lawful status in the UK prior to the transition period being in a much better position than someone who did not have a lawful basis to be there. If you're with me on that absurdity, then in order to get around that absurdity, my learned friend needs to show that, and I think he accepted, that it's very clear that the wording of the definition takes the colour that he says. Now, I know it's not the most attractive submission to rely upon a lack of clarity in the wording, but the Secretary of State...
But to be fair to you, and I wonder if you're underselling your case, we've said all the rude things we can say about how it's drafted, so clotted and unless and all these knots and so on, but if you read it really carefully and break it up in the way that it naturally, with difficulty and labour, but actually once you understand it, naturally breaks up. You're not just saying, oh, well, it's all unclear, so go for the sensible result. You're actually saying, no, the answer, if you work at it enough, is clear.
Absolutely, my Lord. Sorry, go on. Yes, absolutely. In the first instance,
your primary position is hard as it is, once you do the work, it's clear.
Exactly.
Your secondary position is if it's still not clear, then go for the result that leads to the sensible outcome rather than the absurd outcome.
Exactly.
Yep.
So to succeed on this ground, Mr. Wilding would have to not only satisfy you that his interpretation is the better interpretation, just based on the wording of the provision, but he'd also need to satisfy you that his interpretation was so clearly correct that it would get around that absurdity. So yes, I can't put it better than my Lord has. Would it assist if I go through the changes that have been made as a result of the statement of changes?
Well, yes, I think it would, but subject to any my Lord and my Lady may say, can I just say why we want to look at it? At the moment, I don't think any of us, I'm certainly not persuaded that it is strictly speaking relevant. We've got to construe this as at the time that it was applied when you didn't know what the law was going to be later.
Yes.
If I can just fly a kite of my own, there are lots of, we've all been in cases where you ask, is an explanatory note or explanatory memorandum admissible as an interpretation of the regulation which you're looking at? I should take a lot of persuading that it's admissible for the explanatory note of later legislation to say, this is what I meant last time.
Yes. Well, I respectfully agree with that. So I think on the purist point of view, I think we're all with you that we've got to read this as it was in whatever the change date was. Having said that, there are two reasons, one slightly intellectually impure and one better, why we ought to look at it. One is the fact is it has been made, and the change has been made, and this is the impure reason. And it would be a bit odd if a change had been made which on the basis that it was clarifying, which actually said something completely different from what this said. So that's one reason. The other reason is that if we feel able comfortably to do so, even though strictly speaking it would be obiter, it must be in everyone's interests if we confirm not just this is a piece of interesting historical information about what it meant up to June 2023 or whenever the change was, but it is still the position. And that the change, because nobody wants tribunals to have to go on struggling with this. And I think we're up for doing that, provided as a piece of obiter, but I hope very persuasive guidance, providing we're shown why you're right.
I'm grateful. So
yes.
I see those points. I wonder if it might actually be helpful to start with where the Upper Tribunal got to on this exact question in Hani, because again,
if you like, yes, absolutely. Well, now you know why we're looking at it, or why we think we should be looking at it. You do it your way.
Tab 20.
We haven't got tabs. Can you
Oh, sorry. 566 is the start of the decision. And paragraph 38, so 574. And I'll start here just because it not only extracts with the bullet points the critical bit of AAA that we're looking at. So it allows you to see the provision.
So where are we on?
Paragraph 38 on page 574.
Yeah.
But my overall submission is, regardless of whether we adhere to, whether we take into account the fact that the explanatory memorandum says it was the case, that the changes to this provision do only clarify what I think no one's pretending was a provision that couldn't do with clarification. And the way that it does that is by introducing 2 bullet points. And as a result of introducing the 2 bullet points, which follow the unless, it then flips around the otherwise had a lawful basis of stay in the UK. Now,
when you say flips around, what do you mean?
So before it said they did not have a lawful basis to stay in the UK, it converts that negative to a positive, which I think is a point that my learned.
Yeah, quite. Well, that is rather worrying.
Yeah. Can we just go through this a bit more slowly? Because the first part of AAA is unchanged.
Yes.
And I think where everyone seems to be is that's very, well, on the Secretary of State's side, is that's very broad, covers all people who weren't resident on that basis. So it would cover the appellant.
Yes.
And it would cover the person with a student visa.
Yes.
And then we still have this carve out. And take the person with the student visa. Doesn't the effect of the unless, arguably the effect of the unless taken with the second bullet is to carve out the person with the student visa? And maybe I'm just missing something, but I am struggling with that, I have to say.
Well, again, that's not the interpretation of the current provision that the Secretary of State puts
Well,
in.
I know it's not, but it's all very well to say that, but you've actually taken out a not, which was crucial to what you were saying was the correct interpretation, showing my hand persuasively, in relation to the old rule. And now you've taken out the key word that persuaded us you were right about the old rule.
I wonder if going back a step and rather again than trying to use the way in which the new rule is worded to cast light on the old meaning and back and forth.
I think you're going to have to argue, if you were arguing this under the new rule, you'd have to run a completely different argument about the overall construction.
But maybe that is the point. We were looking at some previous rules I've argued the construction of those rules and the proper construction of those rules.
So we're with you on that.
The Secretary of State has sought to clarify the rules, and that is the intention of the new rules. Has sought to make equally, and I'm conscious that the interpretation of the new rules has only been introduced into this case insofar as it reads back.
Never mind.
I take the point
But we've explained we want to deal with them if we properly can.
I understand. But
so assume we were doing a case in which this is what mattered, and assuming that last week, we had decided that you were right about the old rules.
yes,
Now we got a case on identical facts, but about the new rules.
yes. So I would now be seeking to persuade you that the introduction of the 2 bullet points means that if we start from AA, so we, as my lady just said, we're in the territory where a person is not resident as a durable partner, was not resident in the UK as a durable partner of a relevant EEA citizen on the basis that met the family member of a relevant EEA citizen, so someone who is not a family member, not a vanilla family member, at any time before the specified date. We're then into the unless territory. So we've got the broad point, the same as we did before. We then say the reason that they were not so resident is they did not hold a relevant document. So that is met. They did not hold a relevant document in the case of our student. Student did not hold a relevant document. And he otherwise had a lawful basis of stay in the UK and Ireland for the period. So he did have a lawful basis to stay, and therefore the unless criteria is met, and he is able to stay. He does.
You're having to argue precisely the opposite.
I'm conscious of that, my lady. But sorry. Thank you. Yes. But it is essentially that the introduction of the bullet points does mean that you have to slightly flip around the argument.
Well, I thought the answer was going to be something like that the introduction of the bullet points changes the syntax in some way. Well, unless I'm not seeing it, it doesn't.
So I'm being reminded, we have set out how the syntax changes at paragraph 34.
Yes.
Where have you set it out? In the skeleton, did you say?
In the skeleton argument.
Where?
Exactly.
Paragraph
34. So it is essentially. I'll allow you to read that. Sorry.
Yes, let me read. I mean, I've read it obviously before, but let's read it again. It's very elegantly written, and it could be right. At the moment, I just can't see it.
I understand, and
I think it's what you have to say.
It's the best I can say, but the Secretary of State position would be that the syntax is altered by the introduction of the bullet points.
Are you effectively saying that on the new version, the only people who can get within AAA are those who had a lawful basis to stay?
Yes, exactly. So
in which case, it shouldn't be a second bullet point following the unless. It should be a sort of self-standing statement.
That's as maybe.
Well, no, it's rather important. It's not as maybe. I mean.
Well, the Secretary of State's position is that it's still clear, and that the syntax in introducing the bullet points is to try and draw out that point that if someone has a lawful basis to stay in the UK, then they meet that unless criteria, and that's what has been introduced in these new provisions. If the upshot is that they could be clarified further, then the Secretary of State can consider that. But
I think the problem is that you've got the lawful basis of stay within the unless, whereas you want to be within AAA. You don't want to be taken out.
Yes, again, the second.
Well, I mean, another possibility. And we've had to do this with immigration rules before, and it's only something we want to do if we were quite satisfied from the admissible materials that something has gone wrong in the drafting, is simply to say, this read literally and according to the punctuation of the syntax says the opposite of what it obviously means. And in those circumstances, it is open to us. We did it in a case called Hoque, H-O-Q-U-E, to say, I know it says this, but it clearly doesn't mean it. It means that. It has to be a very clear case before we can do that, but that's conceptually open to us. And I think your fallback has really got to be that if we can't find a clever way of making the syntax work, to say what's actually happened here is that in an effort to redraft to make it clearer, they've made it worse. It won't be the first time that's happened. I'm not this time looking at the Home Office. There's other legislation where that has occasionally happened. It happened in the Equality Act, for example.
If we were deciding this case on the new rules, we would obviously be able to look at the explanatory memorandum. And you would be relying, I would imagine, heavily on that.
Yes.
Exactly.
I mean, this isn't just war stories. It's really partly to give Mr. Wilding an opportunity. That there's an Equality Act case where something went completely, not several in fact, with the Equality Act, but this particular one, where it became perfectly clear that the literal meaning, even the natural meaning, couldn't mean what it said. And part of the context was the Equality Act was meant to be preserving the protections already in the previous Act, but we also looked at the explanatory memorandum, which showed no signs that there was an intention to change the law, which apparently now. And we just said heroically, I know it says this, but it clearly doesn't mean it. It means the opposite. A case called Jessamy and Rostock. And Hoque is an example of us doing something fairly similar with the immigration rules. And I just flag up that if you haven't persuaded us, and get at least 2 cold towels from my head before I reach a final view on this, you haven't persuaded us that the new drafting means what you says it means as a matter of language. Your fallback position has to be, this was only ever intended to clarify the position as ex hypothesi you would have held it to be in the old rules. In fact, we made it worse, not better, but it's clear we weren't intending to, and therefore read it as it's intended.
I'm really grateful for that, and yes, in the first instance, my submission would be that it is sufficiently clear for the reasons set out in the statute.
Ultimately, I think goes back to a House of Lords or possibly Supreme Court case called Inco.
Inco choice.
Yeah.
Yes, so in the first instance, I say it would be sufficiently drafted. I think my second observation would be that obviously this is a case that's not focused on the interpretation of the new rules, noting all of the points that you've made, my lord, about the benefits of being able to give observations about how the current rules operate. If it is the case that actually in order to properly understand how these new rules operate, that we do need to look at the explanatory memorandum and so on, then perhaps that this isn't the case in order to decide those issues, but also the point that you...
If we're decided in your favour, you'd like us to do it. If we're decided against you, leave it to another case. Let's just put it off an evil day.
I think that's the highest I can put it, my lord.
Very well. Now, not probably in the way that you had intended, but we have covered quite a lot of the ground. Do you just want to regroup and see what points you haven't yet had a chance to make that you feel you need to make on ground 2, which we're treating as ground 1?
No, I'm grateful. The only other thing that I can do if it would assist would be just to go to the decision of the Upper Tribunal in this case. In short, they said that they like... They
basically said they're following Hani.
Exactly. I only picked that up because I think there was a point suggested in Mr. Wilding's skeleton that the Upper Tribunal didn't properly engage with the issue and improperly followed a decision that wasn't starred or reported in the proper way.
I don't think Mr. Wilding wasn't making any point about this. The question is what the right answer is. Harney is not binding on us, but if we find the reasoning convincing, then it doesn't matter whether it was starred or unstarred or...
Exactly, that's the extent of my point. So other than ensuring that you don't need me to go to the UT decision, that's all I had to say on ground 2, unless I can assist further.
Thank you. Ground
1. So I hope I should be able to take this relatively briefly. I understand the appellant's ground 1. Well, I had originally understood it to be that it was about the approach to the tribunal, in that it was a criticism that the tribunal closed, the judge closed, I think, her mind to the potential that a subsequent marriage could become evidence that was taken into account in relation to durable partnership at the relevant date. I think it maybe has now taken on some more character in relation to the slight quasi-perversity question, which...
I think I'm sorry, it was a rather red herring. I said perversity, but
that the fact of whether all of the material facts have been properly taken into account.
yes, right.
I think just first on the question of law and then on the question of what the judge did in the first tier tribunal, I think simply put that there's not much, or if anything, between my learned friend and I in relation to the law. As he said, we're in the territory of Regulation 9.5 of the 2020 regs. It was originally said that we were in Section 85.5, but the Secretary of State agrees that there's nothing for the purpose.
Okay, and just while we're on those regs, those are the regs under which this appeal is brought, aren't
Exactly.
they? You don't disagree with anything that's been said about
It's
that?
it's an appeal brought on Regulation 8.
And it raises squarely whether you can get within the benefit of the rules.
Exactly,
yeah.
Exactly. And the way that 9.4 operates is exactly as Mr. Wilding puts it. It allows the tribunal... Sorry, 9.5. 9.5 operates is to allow the tribunal, and maybe it's helpful if I just set this up.
It is 9. It is 9.4.
It's 9.4.
Oh, sorry.
9.5 the first time. Thank you.
Perhaps we have to just look at it.
Yes. So it is tab 5. Though I think I'm the only one with tabs.
We haven't got pages of what we want.
Yeah. It is at page 256.
Yeah.
Yeah. And
The
so
relevant authority is the tribunal, isn't it?
the authority.
Yeah.
At this stage.
That's all right. And that's, in a sense, he was quite right. It's been part of the law for a long time.
Exactly.
Going back to some problem in the 90s or something. Yeah.
Exactly, and so the Secretary of State doesn't disagree with the way it's been explained.
But the question is the nature of the relevance, and you don't say it's inherently irrelevant.
Exactly.
Yeah.
Yes, 9.4 squarely allows the tribunal to take matters if they think they're relevant into account. The question is really whether the judge in this particular case did or did not close her mind to those issues, and if she did not close her mind to the issues which the Secretary of State approaches, I think now the question of whether she dealt with them sufficiently and in light of all the evidence. There is a case in the bundle on this, Elias, but I think since there's nothing between my learner friend and I in terms of the proper approach, I don't propose to go there. So if I could just take you directly then, unless it would assist me for me to go.
Just for my benefit, which case? Elias. Yes.
Yeah, sorry, it's at tab. Sorry, you don't have tabs. It's
yeah, I can see it in the bundle.
It's in the bundle. But in short, actually, just to characterise, because we are here in the context of what on the Secretary of State's construction of paragraph AAA is a hypothetical. So the reason that this comes up in the Elias appeal is because it was a case where the individual had made an application under the 2016 regulations, but then subsequently married after the end of the transition period, and his 2016 regulations application had been refused, and so the tribunal was then tasked with considering whether he had actually met the definition of a durable partner for the purposes of the 2016 regulations at the relevant time. And that's why this issue arose on the appeal. And so that case was considering the extent to which the fact of the subsequent marriage ought to be part of the matrix of factual consideration when deciding whether they were in a durable partnership at the specified date. So that's why it comes up in that context. And obviously, given the Secretary of State's interpretation of paragraph AAA, it's quite rare for this to be an issue in circumstances that we're in, where we're dealing with an appeal under the EU settlement scheme. And so there aren't any direct cases that deal with the specific application of the regulations in relation to the EU SS. There's one case called Dano, but that's concerning a different thing about when a new matter is a new matter. So that's why Elias is the case that you're referred to, and not a case specifically dealing with these regulations. But as I said, I don't think there's anything between my learned friend and I on the law in terms of how it's approached. The question is really whether this judge did properly have a think about the relevance of the subsequent marriage when deciding whether there was a durable partnership. So if I could take you to the FTT decision, I think it's at page 89 of the electronic court bundle.
Yes. Paragraph 15, isn't it? Or was it? I'll show us some other
yes,
paragraphs.
No, paragraph 15 is the core matter, is the core bit of the judgment. So if we go straight to that, I would just say at paragraph 14, the definition of durable partner is set out as it appears in part A and then B1 of Appendix EU Annex 1. And you can see there that the judge has underlined the couple live together in a relationship akin to marriage or civil partnership for at least 2 years, but still in the brackets unless there is other significant evidence.
So sorry, I've lost. Oh, I see. On paragraph 14. Yes, got it. Yeah.
Paragraph 14. I'm only emphasising that the judge did set out the definition of durable partner as it relates to a vanilla family
and underlined
other significant evidence. Yeah. Then we get to paragraph 15. Again, my lords and ladies have had the chance to have a look at this, but unsurprisingly, I put particular emphasis on the fact that, firstly, the judge in this paragraph acknowledges that they didn't start living together until a year later and that there was no more than a month of cohabitation, and then specifically comments that it's a very short period and well short of the required 2 years of living together. Again, I think, my Lord Underhill, you suggested to Mr. Wilding earlier that the use of required there might be a bit of a shorthand, and in my submission, based on the underlining of other significant evidence in the paragraph above, that's a fair way to approach this decision. And then it says it's also the case that the notice of marriage was given less than a month before the specified date. So again, looking at the temporality. One other observation there is that the fact that the intention of marriage was given before the date means that even if we were in the territory where this judge was not looking at the subsequent actual marriage, the intention of marriage even before the specified date was part of the factual matrix that she was considering. So,
well, yes, yes, but she doesn't refer to it.
Well, I would say that the notice of marriage is a reference to it.
Yeah.
Oh, sorry.
In the middle of 15.
In the middle of 15. It's also the case that the notice of marriage was given less than a month before the specified date. The specific appointment on Christmas Eve isn't referred to, but...
Yes, sorry. She's referring to it as a point against.
She is, but that shows that it's a point that she's considered.
Yes, I see.
And then I'd say even more helpful for my case is that she says then, whilst I can take into account the evidence at the date of the hearing, which shows a clear recognition of the fact that subsequent evidence can be taken into account, and then she proceeds to find that they are in a durable relationship now, which is part of the kind of general framework that is relevant to consideration under the use. She then says, at the date of the application, I find that the appellant had failed to show that he was the durable partner of an EEA citizen on the 31st of December 2020. So it's still the 31st of December 2020 date that she's focused on in deciding. And the reasons for that are those that are set out in paragraph 15. Ultimately, the decision says what it says. That's the gloss that I put on it, and I would submit that that's the best way of reading this decision, given that she does properly set out the definition that was being looked at and applies the facts to that definition. I would also just say, in relation to the level of reasoning, and I think this feeds in as well to the suggestion that relevant information wasn't properly taken into account. And what I would say is just a point that we make in our skeleton at paragraph 26, which it just goes to the level of reasoning that's required of an immigration decision. Sorry, it's the appellant skeleton 06. It's my skeleton right at the end, which is 84. I can go to the authorities, but I don't think they really go much further than the point that I make, which is that it's very well established that reasons given for immigration decisions in the FTT don't need to be extensive. The relevant points have been identified, and there's no fault with this decision. Obviously, we only get there if I'm wrong about AAA, but unless I can assist further, that's our ground one.
Just one other point. Neither of you in the event, although I think your skeleton in particular refers to the guidance, I think they both do in different ways. I think what you or someone was going to just tell us over, although in the end it hasn't been very central to the argument, what the authorities are about the relevance of guidance.
Yes, my lord. I did have a very quick look at that towards the end of lunch. I wasn't sure exactly which authorities you had in mind. I had. I wasn't either.
I thought there was. I thought there was authority. First of all, there was authority from the House of Lords that said guidance is irrelevant, and then that was glossed by Lord Justice Rupert Jackson in another case, Lord Justice Jackson, I should say. Where he said, oh, well, there are cases in which if guidance shows that the Secretary of State has been interpreting the rules in the way that the claimant argues for, that in those limited circumstances, the guidance can be referred to. Is that called Poc Real, I think?
I would have to... Sorry, I thought I'd get someone. I'd have to go and check that.
But that's from a start. That's an exception to a general rule that you can't interpret the rules by reference to the guidance. That's what I think the law is, and if we look at it at all, and if my lord and my lady agree with me, that's the approach we would be taking to the guidance. So we would need to be told if we've misunderstood the law.
I'm grateful for that.
I didn't myself look over lunch.
No, as I also understand, one would draw a distinction with the explanatory memorandum that introduced the status of changes.
Yes.
Which I assume is more like explanatory notes, and there's plenty of case law about.
Yes. Yes, to make it clear, I was thinking only about guidance, but there is reference to the skeletons to guidance specifically.
Yes, my lord, and I did actually touch that very briefly and never came back to it. Yes, I understand that my learned friend referred to the guidance in the skeleton, I think, as an illustrative point rather than
yes,
a
I can't remember.
Point.
Look, the fact is it hasn't featured much in the argument before us, but I just thought that I'm not inviting further submissions about it. We can see what the skeletons say, but I just wanted to be transparent about the attitude in law which we would take to submissions on the guidance. And unless instructed otherwise by the two of you, that's what I think the law is.
No, I think, as I said, the Secretary of State certainly...
Yeah, but as my lady says, the point about the explanatory notes is different. And Hoke, which I referred earlier, is a case in which we referred to the explanatory notes accompanying the statement of changes.
Understood.
Mr. Wilding.
Oh, thank you. There are a few things to cover. I hope not too long, but they're relatively varied, so please bear with me. But I'll go backwards because I think that's actually the way in identifying the easier parts rather than the unfortunate return to the rules, of which I suspect we might have to do. To pick up on the, my lord, your question to my friend just now about guidance, I don't say that the guidance informs the interpretation of the immigration rule at all. I am familiar with the name of the case, my lord, that you referred to, albeit I confess I haven't read it in a very long time. But in Mahad, which you do have, and I took you to paragraph 10 earlier, this is page 384 of the authorities bundle. And you will recall this morning I left the bit of Mahad I particularly wanted to take to it just after where it's D. That intention, rules are her rules. But that intention, and then this is the bit as to IDIs, that intention is to be discerned objectively from the language used, not defined by reference to supposed policy considerations. Still less is the Secretary of State's intention to be discovered from the IDIs issued intermittently to guide immigration officers in their application of the rules, and there's some reasoning given there.
Yes. So IDIs are simply the old-fashioned form of guidance.
Yes.
And I think this is the decision that was glossed in Potrial. So when I said it was a decision of the House of Lords, I was right.
Yes.
It's that's the one I had in mind. Thank you. That's helpful.
Mahad is the Supreme Court.
Is it?
Just the Supreme Court.
So it is.
Whereas Odolola was the trail end of the House of Lords. So it's Mahad that's the authority about IDIs, specifically in immigration.
Yes. Okay, that's fine. Right. Well, there you are. Thank you. That's helpful. So.
And just
I think there is the gloss in Potrial, but I don't think it would be relevant here.
And just to address the point head on in terms of the relevance of any guidance one way or the other that I sought to rely on in my skeleton, the guidance I was specifically pointing to is that found on the gov.uk website, guidance for applicants. Those are not IDIs.
Okay, thank you.
And you have there are 3 versions of that in the bundle. That are
well,
but I don't.
If you're not, we didn't take them to us first time round.
No.
If you're not relying on them, then the whole point can be closed down.
Yeah, I'm not relying on them to say this says X and therefore you must be with me because Y. It is illustrative to what a prospective applicant sees when they go and look for guidance from the Secretary of State.
In that case, you are relying on them.
Oh no,
for the first reason, or not at all.
I am relying on them. But not insofar as I can't rely on them insofar as what the rule means or does not mean because of the test as set out in Mahad. It's the ordinary language.
So how can you rely on them then?
I rely on them insofar as look at in the same. If I can just reverse to. In the same vein that the immigration rules are a set of administrative policy that a prospective applicant has to be able to read, discern and understand. What we have in relation to what they're also told is what is out there on the gov.uk website, and all I point to in my skeleton as a submission is that this guidance makes no reference expressly that if you don't have a residence card, then unless you're in a very specific category of person, you're not going to be able to apply. But in terms of what the rule means, that is not material that is going to enormously assist you, but is a piece of supportive guidance in the loosest sense that is out there. On what my learned friend's submissions on our ground 1, there's just a very short point I wish to address. and my lord, you picked up on it in terms of putting a proposition to my own friend. Where the first tier says it is also the case the notice of marriage was given less than a month before the specified date, the open question to that is, so what? If the judge is saying this causes me to question whether this is a marriage of convenience, well, the judge hasn't gone that far at all. But what relevance, therefore, is whether someone gives a notice of intention to get married 1 day before the specified date ends or 1 year before the specified date ends. If they're not married beforehand, that's the important point for the purpose of why we're looking at the test as to durable partnership. But as we're looking at the test of durable partnership, was the relationship one that met the criteria for durable partnership as of 31/12/20, had to have existed before, but certainly has to exist as of 31/12/20. The fact that they dropped into the registry office on the 24th of December for their meeting is neither here nor there in my respectful submission. It's difficult to understand what the judge means by less than a month before the specified date. It's of no relevance at all. Ultimately, the relevance is, has the judge properly taken all the evidence that she had before her, including post 31/12/20 evidence that pertains to the existence of a genuine relationship that meets the requirement, the definition of a durable relationship as of 31/12/20. Our submission is that paragraph 15 is simply inadequate, given the evidential picture that she had in front of her. And as canvassed before lunch, Secretary of State was not represented, and there was no cross-examination of any of this. And the second short point is the ending to paragraph 15 says, whilst I can take into account the evidence of at the date of the hearing and find they are in a durable relationship now. But with respect to the judge, and it's really to respond to a point that my own friend made, the immigration rules for someone that is married by the time they apply, they don't need to show they're in a durable relationship after they're married, because the marriage is confirmation of the status of the relationship. So it's neither here nor there. But that's all I really want to say on ground one.
Yeah.
Into the body of ground two, and by way of responding to what my own friend said, obviously we take the contrary position, as I've outlined in my submissions this morning and in writing. And I'm not going to rehash those or reheat those, but there's a couple of points that I just wanted to take the court to. The first is, and there appears to be a suggestion, and both my own friend and I are in agreement that it doesn't matter whether it's EU14 or EU14A, you still get to the question whether the material definition of durable partner is met, and that material definition requires an analysis of what not only AAA means, but also what the offending part of the unless clause means, the was not otherwise lawful in the UK. So we are in agreement on that. And I have some submissions to make about what the difference is between EU14 and EU14A and about joining and what that means. But as a point of principle, my own friend just before lunch made the submission, as far as I had understood it, and I'm sure I'll be correct if I'm wrong, but that Appendix EU is for applications from both prospective applicants in the UK and also from abroad, by way of making an application for entry clearance. I foreshadowed possibly some of that when I was on my feet at the start of the day and dropped in, perhaps unsuspectingly, EUFP, but I just want to just clarify something. That proposition by the Secretary of State that Appendix EU is the relevant immigration rule for an application for entry clearance is, with the greatest respect to my own friend, simply incorrect. And it's simply incorrect for two material reasons. Firstly, there is no mention of entry clearance in Appendix EU. At the start of Appendix EUFP, it tells us that those are applications for entry clearance. And my Lord, Lord Justice Underhill, you signposted this morning to the relatively recent decision of the court that you presided over in Rexhigh, and in Rexhigh the Secretary of State outlined the limited circumstances in which an application for leave to enter could be made from overseas.
Maybe it would be helpful if I clarify. I didn't refer to entry clearance. I was talking about limited and indefinite leave to remain. I didn't understand that we were talking about entry clearance at all.
I'm grateful for that clarification. In that case, my understanding was that was when my little friend was being asked about the question of joining, what joining means. And for the purpose of Appendix EU, joining means pretty much nothing. It doesn't mean that you're abroad and you're applying to join. It doesn't mean that you're somewhere else and applying to join. It is just the term used for that particular criteria in the rule.
I don't think there's a debate about this. I think that's effectively what we were being told earlier.
Well, I'm grateful, Melody, if I've misunderstood.
Yeah, no, it's helpful. I mean, I started this hearing thinking that although there might be odd anomalous cases, joining basically meant coming to this country. But I think you're both saying, no, it's really a term of art to cover people who aren't vanilla family members.
Yes. Yes.
With residence cards, in other words.
Yes. And I'll come to, is there much of a how one gets to joining versus, as my lord puts it, vanilla family members in a moment. But I just wanted to make plain that that the phrase joining really is, as has been said, a term of art. And so where we come to in these rules is, as we can see, either someone applies for indefinite leave to remain where they qualify, or limited leave to remain, or limited leave to enter where they qualify. And as the rules make plain, there's an EU14 and an EU14A. And EU14 is on the basis of a family member of a relevant EEA citizen, and 14A is on the basis of someone, the family member of the joining family member of relevant sponsor. Now, for my purposes, I don't concede that we don't meet one or other, because when we go into the architecture of those definitions, it becomes quite circular in terms of whether you are a family member of a relevant EEA citizen or a joining family member of a relevant person. And the reason I say it's circular is this. We start with what those two definitions mean. And it starts this.
Which two definitions?
The family member of relevant EEA citizen or joining family member of relevant person. The vanilla and the joining.
Yeah.
The family member of a relevant EEA citizen starts at page 181 of the authorities bundle, right at the very bottom of the page. The meat of it's over the page on 182. And the reason that we went to the joining family member definition in the first place is because that's how family member of a relevant EEA citizen starts off the definition.
Quite.
Now, I am going to take you there in a moment, but just for the rest of this definition, we can see that the qualifying criteria, which starts at the top of 182, they are, or, as the case may be, for the relevant period they were, the spouse or civil partner of a relevant EEA citizen, and the applicant, and either married before specified date, or the applicant was the durable partner of the relevant EEA citizen before the specified date, and the partnership remained durable at the specified date. That's the start and end point. Right at the very bottom of the box, we also have, in addition, the family relationship continues to exist at the date of application. So there's the ongoing nature of it. Now that's family member of a relevant EEA citizen.
Sorry, where's this at the bottom?
Right at the bottom, my lord. The box starts with in addition where the applicant does not. rely on the meeting the condition 1, 3 or 6 of EU 11.
Yeah, thank you.
The family relationship continues to exist. So that's the full set of criteria for a family member of relevant EEA citizen. But we can't consider that criteria, of course, unless we've already been to joining family member and don't meet that criteria. Now, if I just ask you to turn to that provision, page 187. Person who has satisfied the Secretary of State included by the required evidence of family relationship that they are, or for the relevant period they were, A, the spouse or civil partner of a relevant sponsor, and we've got the marriage before the specified date, or durable partner, and that was...
Sorry, where I mean, you're taking it.
Joining family member,
Yeah.
A, spouse or civil partner of a relevant sponsor, and Roman 1 AA, marriage was before 31/12/20, or BB, applicant was the durable partner of a relevant sponsor before the specified date, the definition of durable partner in this table being met before that date rather than at the date of application, and the partnership remained durable at the specified date, and Roman 2 AA, after this rather unhelpful unless bracket doesn't apply to this case because that's talking about EU 11A and retained rights of residence, but the marriage or civil partnership continues to exist at the date of application. So far so clear, that's identical to family member of relevant EEA citizen, pretty much. But, and my Lord, Justice Underhill, you, with my own friend, before lunch also said, but there's also the second lot of A's and B's towards the end, which we can see at page 188. And this is where it starts to get very circular very quickly. In addition, the person meets one of the following requirements. They were not resident in the UK and Ireland on a basis which met the definition of family member of a relevant EEA citizen in this table at any time before the specified date. Now, pausing there, the only reason why we're in joining family member definition is because the definition for family member of a relevant EEA citizen has told us to go to the joining bit first. So we're in the joining definition, and part of the joining definition tells us we've got to meet this criteria, and one of the criteria we might be able to meet, they were not resident in the UK on a basis which met the definition of. And so one gets in this very circular spiral as to which rule are we having to look at here.
Chicken and egg, yep.
Yeah. So my submission is it doesn't really matter where we get to, whether it's joining family member, if we are and should have been all along an EU 14A case, then so be it. The decision letter didn't make the decision on that basis, but in my submission, the Secretary of State is perfectly within, obviously, her right to make whatever concessions she wants to, but certainly right to say or acknowledge that it would be the fairest thing that if someone makes an application under one route but can qualify it under another, then the other route will be the one that will be
Yes,
granted.
we haven't actually looked at the decision letter. I'm not really encouraging us to.
No,
it doesn't really matter because on an appeal, all bets are off.
It's all up for grabs,
Yeah.
We either meet the rules or we don't. Yeah. Whether it's 14 or 14A, it makes no difference.
Yeah.
So that is the architecture of these two very peculiar types of relationships. Now, I'm not inviting you to go off on this journey of exploration, but if one looks at the definition of EU citizen versus relevant sponsor, they're basically the same, but then we're directed to continuous qualifying periods. It gets fiendishly complicated. The point of the matter is this: it doesn't matter whether we are vanilla or joining, because what we get to is what does the definition of a durable partner say? And my submission is, contrary to that of my learned friend, that in B Roman 2, so the introduction to the test that we're looking at here, in order to get to AAA is part
We're in backing durable.
Yeah, I beg your pardon, my lord. Yes, page 176.
Yeah.
B Roman 2, about middle of the page there, just perhaps a third of the way down. B Roman 2 is the relevant provision where AAA is found in a sub paragraph, and it was suggested that B Roman 2 is only for someone who is applying as a family member of a relevant sponsor, joining family member of a relevant sponsor. But it's not quite, in my submission, accurate to what B Roman 2 says. B Roman 2 says where the person is applying as the durable partner of a relevant sponsor. Now that's, the relevant sponsor is defined, but it doesn't tell us they're applying as the joining family member. And secondly, of course, the only reference to joining is in brackets there, which is as described in subparagraph A1BB of the entry for joining. So it really, it gets even more confusing when we look at it.
I think we did go to the relevant sponsor definition earlier.
Yeah.
And it incorporates within it joining family member, which is the basis of the
Yeah, I mean,
state's point. But actually, you've already said, and you're both saying, it doesn't matter. So I'm not sure we should...
Really, it was to try and assist the course as best I could from the appellant's perspective as to the structure and navigating.
Yeah, as to why it doesn't matter. No, it's very helpful. We opened this door, so we can't complain of you going through it. But it does look as though you're both in the same position, probably ultimately for the same reason, but we take the rest of the afternoon. We went through all the points.
And the very final submission, my lord, on it, 'cause it riffs from this going into AAA itself, is because of the route that we've got to get to durable partner, the fact that the definition of family member of a relevant EEA citizen asks you to go and look at joining family member of a relevant sponsor, it is neither here nor there for the purpose of the rules. The qualifying rule for the purposes of was not resident in the UK as the durable partner of a relevant EEA citizen on a basis which met the definition found within the rules, it's the criteria there that are important, because that only makes sense when we go to the unless clause. You were not resident unless the reason why you were not resident is you didn't have a document and you were not otherwise have a lawful basis of stay in the UK. So that's how that, in my submission, is to be read through as to how we get there. And then you have my submissions on what that means, and it just is to finally sign off with that when that's broken down into its component parts in our submission, unless married to, they did not otherwise have a lawful basis of stay in the UK, is a set of positive criteria. As I put in our skeleton argument, we're looking at a positive set of immigration rules that someone can meet. In my submission, the Secretary of State's submission, that it only captures lawful people and it captures lawful people, not unlawful people, is not consistent with the ordinary language of that. And for all of those reasons, we would respectfully invite the court to find that EUSS and AAA is to be read as we advance. Unless there's anything further.
Not as far as I'm concerned, no. Can we just revert to this question of the form in which the rules are available? Just to make it clear, this point came up because we were told, and it may turn out not to be right, but we were told that the current immigration rules are not available in the kind of format we have for these two past versions. They only get into that, become available in that version when they are archived. Now, if that is true, it's very worrying for the reason that we gave. So I think we don't want to say anything about it until we know exactly authoritatively what the position is. So if we could have, as soon as possible, but certainly within 7 days, a note from Council, but obviously Council taking from you, Ms. Jackson, but taking instructions from those behind you, stating whether the immigration rules current at any particular date are readily available online in what I will call PDF format, but that's a shorthand for the kind of format of these printouts we have here. They may not technically be PDFs. I say readily available because you've got to picture yourself as an ordinary immigration advisor or even a layperson searching online current immigration rules. Is this the format in which you can get them, in which they come up? So if you could indicate whether that is the case, if so, giving chapter and verse, with the links. Second question, if it is not the case, we would want an explanation of why not, because I should make it clear that we would not regard it as acceptable as, well, the Gov UK website doesn't let you do it in that form. This is important enough, the Gov UK website will have to make it available in that form. But those are the two questions we would like answered. It may be the answer is very straightforward, and that this has turned out to be a red herring. But if it's not a red herring, it's an important point.
Thank you. Other questions?
Right. Subject. Yes. Lord Justice Bean reminds me that this is a purely factual question about what's on the government website. It has no relevance to any of the issues in this case, so it doesn't need to be cleared with Mr. Wilding. And I think it was you who gave us the information in the first place. As a courtesy, perhaps you should show it to Mr. Wilding, but it doesn't have to be an agreed note in that sense.
Understood.
Right. We will, of course, be reserving our decision. Judgments will be circulated in draft in the usual way for the purposes identified in the Counsel General for Wales case with which you're familiar, and they should only be circulated within the clients to the extent necessary for those purposes, and any further circulation not for those purposes would, on the face of it, be a contempt of court. I'm sure you're very familiar with that. Just remains to thank you both for your help on these, if I may say so, rebarbative provisions. Thank you.